Hi Facebook, this is Tim Anderson. Hey, we did a blog earlier today regarding the Worman case, and a lot of you have emailed me and have said that you've had some trouble watching that video. I guess there was a technical glitch on the way we recorded it and uploaded it to Facebook. So if you watched the video this morning, go ahead, and you don't need to watch this when it's the same content. I'm just re-recording this. We're going to upload it in a different format so that you'll be able to watch it and it won't be grainy and choppy. People were saying that there was problems with it. So I'm going to spend about 10 or 15 minutes talking about the Worman case and what that means to the Virginia Democrats' attempts to change the laws in Virginia. So first off, let's recap the previous video made. The first video we talked about was dealing with the expected changes that were going to come down the pipeline. Most importantly, there's going to be some kind of an assault weapons ban. Now, I'm using the term assault weapons like the governor has used the term, which is an unknown at this point. Is an assault weapon going to be an AR-15 kind of a gun? Is it going to be a pistol that can hold more than 10 rounds? It's impossible to know this, all right? So we're not going to be able to define what an assault weapon is. Now, let's talk about, I see your questions. I'm not going to address the questions right this minute, but I will get to them after the video. So thanks for posting. Post your questions here, and let's talk about it. So first off, let's talk about what the Second Amendment says. So if you've ever read the Second Amendment, it talks about the freedom of owning a firearm for the purposes of having a well-regulated militia. And there's been lots of talk back and forth about whether or not you can own a firearm for self-defense. And so because even as recently as a decade ago, that was unknown as to whether you and I can actually own a gun pursuant to the Second Amendment for home defense or for hunting or for something like that, the Supreme Court engaged in a case called the Heller case. Now, what Heller basically was about was the District of Columbia passed a rule that said, law that you cannot have a handgun in your own home at all unless you go through all of these certain regulations and procedures and so forth. And so the Supreme Court flat out said that's not going to be the law in the United States. The Second Amendment extends the right to an individual to own or possess a firearm. Okay. So that's settled. So if anybody's still talking about that, that's been settled. I get to own a gun to possess in my home or for lawful hunting, for self-defense, for other issues that are not related at all to having to have a militia. All right. So anybody who's still talking about that, not the law. All right. The Supreme Court of the United States clearly and unequivocally said a private citizen can own a firearm for self-defense. Now, it has not said whether I can carry that firearm around in public, in a concealed fashion, or an open carry fashion. It was very limited to home defense and for hunting. But very importantly, the Supreme Court clearly said in the Second Amendment, as a result of the Second Amendment, citizens of the United States can own firearms for lawful protection. Okay, so that's the law. That's where we're going to start off at. Now, since then, and even before then, lots of states have passed assault weapons bans. California, Connecticut, Massachusetts, things like that. Those states. So when that has happened, the court allows those to happen because there have been two components to the law. First, there's a grandfather clause, which means that if you own the firearm prior to when the law kicked in, you would not be considered a felon. The second thing that the states have done that have implemented these rules is they made it to where you cannot have a firearm that you legally owned and now would be considered a felon to own it down the road. And so you have this grandfather clause, and then they narrow it down to say, hey, it's only going to be these kinds of weapons. Something that looks like an AR-15, for instance. Something that holds 30 rounds, that's self-loading, that has a magazine, that is detachable, has a folding stock, whatever it is, it's pretty narrow. It has never gone so far as to saying it is for pistols or it is for rifles that might be something less than what a typical AR-15 can hold. So, pretty narrow ban, and it had a grandfather clause. And the courts have allowed that to happen. Now, Virginia seems to be going in even a more aggressive approach. The governor has recently talked about confiscation. The governor recently talked about defining assault weapons as any gun that is more than 10, that can hold more than 10, which would be pretty much any pistol that modern day people have owned. All right, so what's going to happen in Virginia is an assault weapon is going to be what the General Assembly says it is. If the General Assembly says that an assault weapon is everything that is more than 10, so it's going to be talking about pistols, shotguns, rifles, things like that, then that's a big problem, and Heller is going to kick in. Okay. Now, if you all remember this guy, I don't know if you can see this very well, but Mitt Romney. Mitt Romney was the governor of Massachusetts. Now, he's a Republican by the R after his name only for this part. But Mitt Romney, when he was the governor of Massachusetts, enacted and signed into law an assault weapons ban, which in this particular thing was mostly like AR-15s, AK-47s, things like that. When he signed into law, his quote was that these type of large capacity firearms are not for recreation or self-defense. They are instruments of destruction with the sole purpose of hunting down and killing people. Okay, he said that. Now, the problem with him saying that is that when we're dealing with the how the courts are interpreting that kind of polluted language has flowed into the courts. So, the Governor Mitt Romney's not been the governor for a long time. Now, again, if you're just tuning in and watching this, I'm sorry, I'm re-recording this because the video we made this morning was corrupted and was not working properly. I got several emails from some of you. So if for some reason this video is not working correctly, please email me and let me know. We'll find another way to format it. It wouldn't surprise me if Facebook's playing games with us trying to get this message out to people, because this is a very pro Second Amendment video. So please let me know if it's not working correctly. All right. So going back to Mitt Romney, AR-15 type of weapons are instruments for the sole purpose of hunting and killing people, not for self-defense, just for hunting and killing people. Well, finally, the some gun activists and gun groups have been challenging this, and when they challenged it and lost, they went to the First Circuit Court of Appeals, which is very liberal. And the First Circuit Court of Appeals said that whenever you're restricting a firearm, such as just an AR-15 or something like it, an AR-15 is only going to be the target of the law, then that does not interfere with the Second Amendment. And it also does not step on Heller, because Heller says that we have a right to defend ourselves, but it doesn't say with what, whether it's pistols, shotguns, rifles, AR-15s, or whatever. So because we're only striking this one type of gun, it doesn't interfere with Heller. All right. So what happened is Judge Scalia in the First Circuit basically regurgitated Governor Romney at the time, now Senator Romney of Utah, but Governor Romney's sentiments that basically AR-15s have no purpose other than hunting and killing people. I think we just read an article the other day out of California where a pregnant woman shot and killed a home intruder who had her husband at gunpoint, and she used an AR-15 to neutralize the perpetrator. But let's not talk about facts here. We're only going to talk about the salaciousness of the people that are, trying to make the law. Judges are Democrats, judges are Republicans. They're going to see things one way or the other, and clearly in the First Circuit, the judges see things the way that a very liberal Mitt Romney, although Republican, saw things. So what happened is In that court case, the case said that equally as important, the record does not show it offers any indication that the prescribed weapons have commonly been used for home defense. Viewed as a whole, the record suggests that wielding the prescribed weapons for self-defense within the home is tantamount to using a sledgehammer to crack open the shell of a peanut. Now, I don't know about you, but I would much rather have a sledgehammer to crack open a peanut when we're talking about the peanut being a home intruder, right? I don't know how you feel about this, but if a home intruder is coming into my house, I want to be able to neutralize him with any and all options I have. The stronger the firearm, the better. If I could have a bazooka, I'd like to shoot him with a bazooka. If I can have an AR-15, I want to shoot him with an AR-15. We're talking about a home intruder here. But the First Circuit deminimizes this and says, hey, you don't need an AR-15 to defend yourself. You don't need these things. You only need a pistol. You only need a shotgun. You don't need this kind of a gun. And by having this kind of a gun, it's no different than if you need to crack open a peanut, instead of using a nutcracker, you have to use a sledgehammer. That's absurd. Now, because of that, this case is now before the U.S. Supreme Court in the case of that we've just been talking about. Now, that case is cited up here. Look up here in the comments so that you can look at it. Worman versus Healey. The question before the court is can you restrict a firearm, a particular type of firearm? That is the question that's before it, and it's not talking about whether you can have a revolver. It's talking about whether you can restrict a firearm for the purposes of owning a firearm for particular self-defense. Now, keep in mind, the federal government, which has exclusive rights on gun regulation, on what you can and you cannot purchase legally in the United States, has said that you can buy an AR-15 legally, and anybody who owns one owns them legally and lawfully under the law. How the states have carved out the exception to that is they have said, hey, you are not allowed to own this, you can't buy this kind of firearm after this particular date. Not in our state. Now, you can maybe buy it in Nevada, but when you buy it in Nevada, you can't bring it in here. You have to have owned it before this date. And so those have held water. Those have held, the courts are not going to interfere with that. If Virginia comes in and says, we are going to ban AR-15 types of firearms, guns that are like AR-15s, and that is it, we're just banning them, and there's a grandfather clause that says if you've owned them before this particular day, the federal courts are going to have very limited recourse to be able to enjoin or put an injunction in place. However, the nut jobs are running the asylum now in Richmond. They are going to go full-blown to the left, and when they do, they're going to step on the Heller provisions. They are like a rabid dog right now, foaming from the mouth. They are not going to be able to control themselves. They're going to put everything that they can put as a restriction, and the more that they put in, the more they're going to step on Heller. If they step on Heller too much, the federal courts will have the tools that they need from Heller to be able to strike them down. If they step on the rights just a little bit, just like pretty much Massachusetts has done, or even California has done regarding banning a particular weapon, then Worman is going to have to be the answer. Now, Worman is before the Supreme Court now. Oral arguments haven't been set yet, but there's deadlines that are in December. It's going to be heard in 2020. When it gets heard in 2020, it's going to be decided in 2020. And when that happens, we're talking about the definition of what Heller meant. So we've got a good majority on the Supreme Court. However, Justice Roberts has been a little, to the left here and there on certain things. And so what Worman says is going to define whether Virginia, California, Connecticut can defend, can have the types of firearms that are considered like AR-15 types of firearms. So, good news is, Good chance with Governor Northam talking about confiscation, talking about making things illegal of over more than 10, making you a felon for owning something that you've lawfully bought. If he does it, if they do it, we have Heller. Okay, that's a big, big tool in our tool bag to be able to push back. If they dial it back and come into more of a, oh, hey, we're just trying to make it a safer world and not have AR-15s out there, just AR-15s, that's all we're trying to deal with, then whether or not they can do that is decided by the Worman court, which is going to be decided in 2020, and that's going to determine whether anything Richmond does in this legislative session in January is ever going to get out of the gate. Richmond passes rules in January and February. Those laws become laws in July 1, and Worman should be decided before then. If that happens, and Worman comes our way, then you're not going to be able to ban AR-15s, period. It's going to have to be done at the federal level, all right? And when they do ban it at the federal level, they're going to have to do a workaround to get out of the way of Worman and Heller, and that's going to be a big pill to swallow. So what we're probably going to see is the Supreme Court say you can't ban these types of guns. Either you can defend yourself or you can't, period. You can't, they're not going to say you can only defend yourself with this kind of a gun and not this kind of a gun. The only way that, if that happens, that AR-15s would be illegal is if the federal government put them on the NFA list, and we would have to go through some additional background checks to purchase them and all that kind of stuff. But that would be up to the federal government to do. You can buy M16s today. You can buy short barrel rifles today. You have to go through the NFA rules to be able to purchase them, but you can still buy them. Maybe worst case scenario, the AR-15s will end up on the NFA list, especially if Worman comes our way, and you can't ban them. If Worman comes our way, California is out, New York is out, Connecticut is out. All this crap is out the window if Worman comes our way. So that's a big one to watch. It's going to happen in 2020. We're going to get some crappy rules coming down from us in 2020 from Richmond, and it's all going to come to a head probably in July of next year. So hope out there that whatever Richmond passes, we are going to have a lot of tool bags to fight with them in the federal courts. Hope for more radical than less radical. I know that's weird to say, but you want to see Richmond come out with you want to see Richmond go further away than anything California or Connecticut has done. The further away they go from the middle, the better chance we're going to be able to knock them down. Attorney Tim Anderson, November 11th, 2019. Happy Veterans Day to all you veterans out there. Keep us tuned in. I'll give you updates as Worman is working its way through the courts, and I'll give you updates if anything else comes down from Richmond when they're known. Have a great day.